and whatever construction had been made to be demolished. My lord, we came up on appeal. My lord, the Court of Appeal, my lord, granted, my lord, a stay with regard to demolition and asked the railways, because no affidavits had been filed, nor had any directions been given by the learned single judge.
This was a writ petition.
Writ petition, my lord, it happened, my lord, on, my lord, the first, my lord, hearing itself, without affidavits. No affidavits were called for, but there's finding of fraud, collusion, without, my lord, even, my lord, an averment to that effect in the writ petition. And, my lord, the result was, my lord, that, my lord, this industry, my lord, has basically remained shut. My lord, in spite of a resolution plan having been, my lord, approved, the secured financial creditors all paid, I am out of pocket, but, my lord, I can't, my lord, revive the plant.
Which was prior in point of time, revival of your permission or permission granted to them regarding the...
For them, my lord, 2019, my lord, 2019 they had one and 2022. But they applied, my lord, while, my lord, my permission was existing.
Prior to 2017.
In 2017, but before expiry of, my lord, mine.
All right.
My lord, this is, I'll give a list of dates. My lord, I have a list of dates. But, my lord, this is, my lord, the position. Now, my lord, I want to, my lord, take your lordship through the, my lord, order, my lord, which has been impugned. Yes, my lord, I will, my lord, show your lordship first the impugned order, then, my lord, the interim order, my lord, which has been passed, my lord, by the division bench, my lord, which, my lord, actually, my lord, tries to, my lord, focus on, my lord, two issues, my lord, on which, my lord, the court wished to decide. I'll, my lord, show that to your lordship. My lord, kindly come to, my lord, first the impugned order. My lord, it is kindly take the memorandum of appeal instead of, my lord, the bulky, my lord. My lord, no, memo, pen thege dakho. My lord, kindly takes an order of 10th of May, 2024. My lord, it's annexed to, my lord, the memorandum of appeal. My lord, may I, my lord, just indicate, my lord, pages 1 to 7, paragraphs 1 to 3, 1 to 23, my lord. I'm just giving a, my lord, summary of what is there rather than, my lord, placing everything. Pages 1 to 7, paragraphs 1 to 3, my lord, are the submissions of the writ petitioner. Now, my lord, locus, my lord, has been claimed, my lord, in paragraph, in page 6, my lord, kindly have a look at page 6. Paragraph, my lord, 23. My lord, paragraph, my lord, 22, paragraph 2 and, my lord, paragraph. My lord, kindly come to, my lord, page 6, my lord. This is, my lord, my lord, the locus issue. Kindly have a look. Para 21, my lord. Kindly see. Para 21, page 6. The argument of the respondents, lordships have that, my lord, that the petitioner has no locus standi to complain since its underpass will not be affected is refuted by the petitioner. Learned senior counsel for the petitioner argues that the effect of the purported renewal of license from 2017 to 2027 would directly interfere with the petitioner's right to operate its underpass. And, my lord, para 23, page 7, it was further argued that the construction of the overhead pipeline proposed by the respondent number 6 would directly jeopardize the underpass of the petitioner, since no specifics of the structure have been disclosed even in the plan relied on by respondent number 6 and or approved till date by the railways. 6 is, my lord, the appellant. My lord, we were respondent number 6 before the learned single judge. This is, my lord, their my lord, case, my lord, made out, my lord, in the writ petition. Now, my lord, other than that, my lord, they, my lord, argued 3 points, which, my lord, I'm just indicating to your lordships. My lord, there's a railway code with regard to, my lord, grant of, my lord, way leave permissions. My lord, they, yes, my lord, it's known as the Railways Engineering Code. My lord, they relied on 2 clauses. Clause 1033, my lord, subclause 3.2, my lord, that your lordships will find at para 9, page 3. My lord, they said, my lord, no way leave permission should have been granted because, my lord, there is, my lord, an alternate source of water supply. And second, my lord, was, my lord, that very railway code, clause 1033.12, which is referred to in para 10, my lord, page 3, that, my lord, where, my lord, there is any, my lord, overhead pipeline, my lord, you cannot have any construction. Construction is only permitted where it's an underground pipeline. Here there is an overhead construction which could not have been permitted. Overhead pipeline. These are the 2 points, my lord, which were taken. Third point which was taken is, my lord, way leave permission had been granted before design approval. That's para 11, page 4. And, my lord, last point, my lord, which was taken, other than, my lord, the locus, to justify his locus, my lord, is, my lord, that it was contrary to a master circular issued by the railways dated 4th October 2022. 4th October 2020, 2022, 2024, no, 2022. 2022, my lord, 4th October 2022, 2002, not 22, my lord, 2002, that, my lord, renewal could not be, my lord, effected, my lord, on the basis of the circular because the existing way leave permission, my lord, had already, my lord, expired. This was, my lord, the point, my lord, which was taken. Now, my lord, we, my lord, dealt with this. My lord, we made our submissions, which are your lordship will find para 24 to para 30. I'm just summarizing, my lord, then I'll show the findings. Para 24 to para 30, pages 7 to 9. And, my lord, specifically on locus, the lordship kindly sees para 24 and 25 at pages, my lord, 7 and 8. I want to point this out because this is the first point I wish to urge, my lord, because if I succeed on locus itself, my lord, that's the end of the matter. My lord, kindly see, my lord, para 24. Learned senior counsel appearing for respondent number 6 in reply contends that the writ petitioner has not approached this court with clean hands, since at the juncture when the respondent number 6 had shut down its operations in June 2010, it had an existing way leave permission for its pipeline, which had been granted on July 10, 2007 and was valid till July 2017. The respondent number 6, not being able to service its loans, applied under section 10 of the Insolvency and Bankruptcy Code for a corporate insolvency resolution which commenced on January 8, 2018. The petitioner and a consortium of SS Natural Resources and Shamsel Power Limited applied for being selected to revive the respondent number 6. The committee of creditors accepted the bid of the resolution applicant, and, my lord, respondent number 6 was declared as it should be a H1 bidder. The writ petitioner, having failed to acquire the respondent number 6 company, caused a financial creditor of the respondent number 6, and this is recorded, my lord, in orders, to apply for liquidation of the company on the basis that the petitioner was available to purchase assets if sale was conducted in liquidation, which attempt of the petitioner was also foiled. Having so foiled, the writ petitioner has sought to deter the present endeavor of the respondent number 6, which is sought to be revived by its new management as a competitor of the present management of the respondent number 6 in order to render the resolution process infructuous and defeating the very objective of the IBC of corporate insolvency resolution in a time-bound manner for maximization of value of assets and to promote entrepreneurship. Then, my lord, it is next argued by respondent number 6. My lord, the first bit was not having come with clean hands. The second, my lord, is on locus. It is next argued by respondent number 6 that the petitioner has no locus standi since the way-leave permission does not affect the petitioner's underpass in any manner. The approved drawings handed over to the court would show that no work is to be carried out underground, nor is the pipeline going to rest on the roof or over the underpass of the petitioner. There is a gap of 500 millimeters between the roof of the underpass and the pipeline over it. Thus, the petitioner is not going to be affected in any manner. Now, my lord, these were the submissions. Now, my lord, only one point also kindly bear in mind. My lord, trains go over the underpass and nothing happens through the underpass. There is, my lord, a pipe which is 500 millimeter in diameter. 500 millimeter in diameter, my lord, which is, my lord, not even, my lord.
No, not in diameter, the distance between the top of the underpass.
My lord, both. My lord, I'm coming to, my lord, I'm giving your lordship, my lord, an idea, my lord, of, my lord, what an impossible case, my lord, this was. My lord, the pipeline, my lord, the total length of the pipeline, my lord, I'm just factually, I have some models as well, is 2,250 meters. Total length of the pipeline. I'm getting water from the municipality in that area. My lord, 38 meters is above ground. They have two underpasses. My lord, one underpass, my lord, is of a 10-meter span and another, my lord, is 18-meter span. So only at those places it is overground, which is a total of, my lord, 1.7% of the total length of the pipeline, which is all underground. 1 minute. Now, my lord, the, my lord, pipe, my lord, is, my lord, of 500 millimeter diameter. And, my lord, it is 500 millimeter, that is half a meter above the railway line. Because, my lord, it is resting on, my lord, not the underpass, but, my lord, on a steel, my lord, girder type. I'll show your lordship, my lord. So there's no pressure on the underpass, which comes up from underground, my lord, at a distance on either side, my lord, of 2.5 meters from the underpass. So there's no connect, my lord, to the underpass. Rather, my lord, railway tracks are on the just on the ceiling of the underpass. Trains pass on that, my lord, there's no problem. But a pipeline which doesn't even lie on the underpass is supported by another structure, my lord, is what is, my lord, being, my lord, urged. And these drawings, my lord, are approved by the railways, construction supervised by the railways. This is, my lord. Now, my lord, having taken these points, now kindly have a look at how the learned judge, my lord, has dealt with all this. And then I'll show your lordships, my lord, the my lord, documents and the orders passed by the division bench as well. My lord, kindly take, my lord, the findings now, my lord, which start from para 31 at page 10. My lord, the learned judge identifies, my lord, the issue at para 31. Kindly see, the issue which has fallen for consideration is thus whether the grant of renewal of way-leave permission to respondent number 6, which had expired in the year 2007, is valid in the eye of law and or interdicts the rights conferred in the meantime on the petitioner in any manner. Miller, this is how, Miller, it should have been two separate according to me, but anyway, Miller. Then the admitted position is that the wayleave permission granted to the respondent number 6 company on July 10, 2007 had expired in the month of July 2017. Now, my lord, kindly note this. So, my lord, I am, my lord, according to the learned judge, going out of the picture in July 2017. My lord, I will show, my lord, you have a physical copy of the list of dates. Yes. Give it to me. Give it.
When was this construction made by you, by respondent number
24, my lord, after the permission. Now, my lord, what is important is, my lord, kindly just make a note, my lord. My lord, June 2010, the plant was closed. There was no business, my plant. My lord, I made a reference to be registered, my lord, with the BIFR, my lord, because, my lord, I had, my lord, a negative net worth. Statute mandates, I have to do it. That was the old avatar, my lord, of revival, my lord, the Sikh industrial companies.
Section 20.
Correct. Now, my lord, this, my lord, we do on 7th November 2012. Now, my lord, there was an order passed, my lord, in the BIFR proceedings, my lord, on 19th February 2014, that by BIFR, that my reference does not lie. My lord, that was carried in appeal. In the appeal court, my lord, the appellate authority, IFR, my lord, this was, my lord, set aside. This was 3rd of December 2014. All this is happening, my lord, when my wayleave permission is still in place.
We are not noting because you'll give us that.
I'm giving. My lord, this is only while dealing with the order, then one by one, my lord, when I take the points. Then, my lord, the last hearing before, my lord, the BIFR, my lord, was 24th November 2016. My lord, framing of scheme, etc., which has to happen. My lord, 25th November 2016, enactment that from 1st December 2016, my lord, SICA, my lord, if I may use the expression, my lord, abbreviated form, the Sikh Industrial Special Provision, Sikh Industrial Company Special Provisions Act 1985, my lord, would be repealed. And, my lord, there was a provision that within a span of 180 days, my lord, after it abates, my lord, because of the repeal, my lord, we can, my lord, make an application under the IBC, Insolvency and Bankruptcy Code, for revival, which we did. So, my lord, 1st December 2016, IBC came into force. 2nd May 2017, my lord, we had applied under Section 10 of, my lord, the IBC for resolution. Now, my lord, my wayleave permission, my lord, expired, my lord, only, my lord, on 9th of July. 9th of July 2017, after, my lord, the, my lord, application under Section 10. So, my lord, the fact of the matter is, my lord, we could not avail of this. We could take no steps because, my lord, we had, my lord, we were insolvent. And, my lord, we had taken steps first before BIFR, the appropriate authority, for resolution of this, my lord, insolvency by way of scheme, my lord, whatever, my lord, measures the BIFR would have thought appropriate. And when that act was repealed, my lord, we went, my lord, in accordance with law before, my lord, the, my lord, adjudicating authority, which is, my lord, the National Company Law Tribunal, for resolution. So this fact, my lord, is, my lord, very important and needs to be noted here, which, my lord, the learned judge has not referred to as all. Now, my lord, this Section 10, my lord, and this is very important, my lord, gets admitted, my lord, on 8th of January 2018. My lord, another thing is also important. Before July 2017, my lord, on 2nd May 2017, the respondent number 1, while my permission was subsisting, made an application for way leave permission for an underbridge. Now, my lord, it's another matter that, my lord, the railways granted, my lord, that permission, my lord, on, my lord, February 2019. That is after 2017. But, my lord, after, my lord, my resolution process had been admitted. My lord, all these were, my lord, relevant facts. Now, my lord, the rights of the petitioner, now, my lord, kindly note this, regarding construction of an underpass were first created by way leave permission on February 1, 2019, followed by an agreement dated 27, and next by way leave permission of June 1, 22, followed up by an agreement dated so and so. Now, my lord, this is, my lord, very, very important. Thus, when the petitioner was granted such permission, there was no existing way leave permission operating in favor of respondent number 6. Such permission having expired almost 2 years prior thereto was in no manner subsisting at the juncture
এক্ষুনি কিছু লিখে দিতে হবে।
Wednesday, Thursday, Friday বসছে না।
উঠে দেব না, না উঠে দিই।
নারায়ণ রায়ের সঙ্গে বসে। Such renewal has to occur before the expiry of the previous permission, or at least within a reasonable time immediately thereafter. The renewal can be subsequent to expiry also. The agreements here specifically provide for it also.
Extension may have to be within
Correct.
the validity period.
But not renewal. My lord, we can have leases also, my lord. Here, of course, there's no lease. It's a way leave permission, my lord, with retrospective effect.
Those Vishwabani properties and all
Correct.
those cases.
Correct.
Hmm.
Now, my lord, second, my lord, there is a distinction between renewal and novation. The moment a previous permission expires, it ceases to exist and there cannot be any renewal of the same. Now, my lord, I pause here. This is contrary to the previous paragraph. You can have a renewal subsequent, but it has to be closer in point of time to expiry. Then, my lord, anyway, leave permission granted thereafter would be new contract permission. The common sense principle applies all the more in the present case, since the renewal sought to be granted is after a prolonged period of 7 years, long before which the previous agreement had been given a decent burial. One cannot just come up after 7 years and say that a dead permission, which had met its demise 7 years back, is sought to be renewed. Thus, for all practical purposes, the description of a fresh leave permission as renewal, now kindly note this, was nothing less than a fraud practiced upon the petitioner in collusion between the railway authorities and respondent number 6, as well as a fraud on the applicable laws and regulations. My lord, not one averment, my lord, in the writ petition.
Yes.
Now, my lord, kindly have a look at para 37. There are several other discrepancies as well. My lord, one is on renewal, my lord, that it's a fraud. Now, second, clause 1.3 of the policy of management of railway land, which is binding on the railway authorities, having the force of law, since issued by railway board and having been relied on by railway authorities time and again, the said policy is applicable for grant of lease, license, leave permission for all cases under consideration, new cases and renewal of cases. Clause 7.4 contemplates renewal. The language is that on expiry of lease, now kindly mark this, my lord, renewal is contemplated after expiry in that, my lord, document. The language is that on expiry of lease, license, leave agreement, further renewal up to 35 years or for a period as stipulated in the agreement can be done based on mutual agreement. This, my lord, policy itself is contemplating renewal after expiry. Then, my lord, clause 7.5.2 thereof deals with existing users of leave and stipulate that all existing leave facility users shall be able to migrate to this policy regime, the policy regime, only after expiry of existing leave agreement and payment of all dues. The respond number 6. Now, my lord, the migration for those who already have a leave permission is after expiry, my lord, of that leave. Now, my lord, kindly see, my lord, the next sentence. Respondent number 6 was not an existing leave facility user, nor was the leave granted to it a renewal for two important reasons. My lord, if migration, my lord, if renewal can happen after expiry, if migration can happen, my lord, after, my lord, the previous leave permission has expired, my lord, now in that context, kindly see, the leave permission had expired 7 years back, and any grant after such period can only be a fresh leave, not a renewal, particularly as no application for extension of the previous leave had been filed during its subsistence or was pending at any point of time. My lord, it fell from your lordships. Extension before expiry. Renewal can happen during, my lord, agreement for renewal. It can also happen subsequent, because it's treated, my lord, like a fresh. My lord, extension is, my lord, the earlier lease or earlier grant, whatever it is. My lord, this distinction has, my lord, completely, my lord, been forgotten here. And second, most importantly, my lord, the policy itself is saying, my lord, that you can migrate only after expiry. So this policy can be applicable only after your previous leave permission has expired. And second, it's after expiry that you can have, my lord, a renewal. Now, my lord, second, Now this is even better, my lord. Kindly see. Such renewal totally suppress the valuable rights created in favor of the petitioner in the meantime by virtue of the valid leave permissions and follow-up agreements granted in February 2019 and June 22 respectively, which has been fully acted upon by the petitioner by expending huge resources with the approval of railways and having built and put into operation the underpass in question. Such valuable rights cannot be taken away at the stroke of a pen merely by describing a fresh leave which is mutually exclusive with the existing rights of the petitioner as a renewal. Now, my lord, I pause here.
How does it really make a difference if it's a fresh permission or a renewal?
Doesn't. My lord, number one, it doesn't. Second, my lord, there is no right of the petitioner. My lord, I could have understood, my lord, his railway underbridge is being destroyed. That's not happening. And my lord, the agreement which I referred to here, say, my lord, no right is being conferred on the petitioner.
You filed affidavit in opposition?
No. It happened, my lord, during the course of arguments. My lord, they wanted interim orders. We were opposing it. He said, the learned judge said, I will dispose of the writ. We filed a compilation to show our drawings. And my lord, finding of fraud, my lord, finding of collusion, finding of fraud on the regulations, finding of fraud, practicing of fraud, my lord, on the petitioner. My lord, couldn't even have argued that case. It's not there, my lord, in the writ petition. Now, my lord, now that we are here, I just want to show one of the agreements. My lord, your lordship sees February 2019, June 22. They are identical. My lord, February 2019, my lord, is at page 75, my lord. My lord, of my lord, our stay petition, my lord, your lordship kindly takes that can 1, my lord. Lordship has that, my lord. Page 75, my lord, agreement dated 27 February 2019.
Yes.
My lord, kindly have a look at clause 12. Page 20, my lord, page 79, my lord. The permission hereby granted shall not be deemed to create any tenancy, kindly note this, or right or interest in favor of the party or over that portion of the land occupied by the party of railway line under or upon which the pipe is laid. He gets no right in any event. And, my lord, the learned judge, with the greatest of respect, has held, my lord, that the leave permission in my favor, my lord, destroys a right.
And this is your pipe? No, the pipe?
Yes. This is my pipe which I had laid. So, my lord, he gets no, my lord, interest in the line under it or upon which the pipe is laid. And, my lord, all the land occupied by that party, which is the RUB. My lord, may I just, my lord, read? My lord, kindly take clause 12, my lord. Again, my lord, may I just read it? The permission hereby granted, that is to the writ petitioner, shall not be deemed to create any tenancy or right or interest in favor of the party. So, my lord, it creates no rights. Then, my lord, or over that portion of the land occupied by the party, that is the railway underbridge, of railway line under or upon which the pipe is laid.
No, this is their pipe, not your pipe.
Well, I don't have a pipe. He doesn't have a pipe.
Paragraph 3, page 76.
Yes. এটা
Pipe.
কোনটা দেখাচ্ছ? এটা আমাদের। Huh? Well, this is, they have no pipe. They have an underpass. They don't have a pipe, my lord.
This several paragraphs talk about pipes.
Yes, my lord. Let us assume, my lord, they had a pipe that it's theirs, but they don't have it over the land and there's no interest. Nah. My lord, maybe it's a standard clause, my lord, which is, my lord, also, my lord, incorporated. Now, kindly have a look at clause 22, my lord, at page 82. Now, my lord, kindly have a look at 22 first, page 82. The applicant, that's them, shall make good any damage to or loss of railway property. Now, my lord, next, or property of the third party due to the presence of the pipe cable facility, and shall pay the cost of making good any damage or loss, if any, cost to the property of the administration or property of third party during the course of constructions, maintain, renewal, additions, alterations, repairs, use, or dismantlement of the pipes cable facility as increased by usual supervision in order to prevent such necessary precautions. Now, my lord, kindly have a most important, my lord, 29. My lord, page 83. The railway administration reserves full rights to enter upon, pass through, or use the land at any time without any notice to the applicant. My lord, it's railway land. My lord, they can, under this agreement, in spite of granting a way-leave permission, whether for pipeline or, my lord, a railway underbridge or railway overbridge.
It's nothing more than a license.
It's bare license. At the highest, my lord, their policy says it's not even a license. It's not even a license. It's basically, my lord, permission to use.
Permissive user, that is right, the
Correct.
license, bare license.
Yes. Bare license.
They can revoke it at any time.
Anytime. Nobody can have, my lord, a vested right here at all. My lord, same agreement with us. Same.
But if it's a license with coupled with interest in land,
That's different, my lord. That's not the case. It cannot be.
anyway, that's not the case.
Yes, and my lord, in the state of West Bengal, my lord, the Easements Act also, my lord, does not apply.
None of the provisions.
No.
The act doesn't apply.
My lord, the one view was principles apply.
Yes.
My lord, Supreme Court has now, my lord, a case which went from Assam, my lord, held. If, my lord, act doesn't apply, question of principles applying does not arise. So, whenever you look at something like that, you look at it with justice and good conscience. That there is a written document, after all, court can always interpret it. And, my lord, it's also been held, my lord, that even where licenses, my lord, even if it were covered under Easements Act, my lord, is not, my lord, exhaustive. My lord, all the provisions which have been. Because, my lord, it can by agreement be made irrevocable also. Anyway, my lord, we need not, my lord, get into that. I'm just showing, my lord, that, my lord, how, my lord, the court, without examining this issue, my lord, has actually come to the conclusion, my lord, that grant of a way-leave permission to me per se is a violation, my lord, of a right. Because he has no right, my lord, in, my lord, the land which he occupies.
Any evidence of possible damage to
No.
his?
I'll show your lordship the division bench order, my lord. I'm coming to that, my lord. I'm just.
These are disputed questions. Anyway, yes.
No, my lord, your lordship's absolutely right. That was our case. There was no evidence at all. My lord, the order which my learned friends obtained, my lord, was for not only recent.
We are making these comments for your benefit. Please note these. You'll have to address these. We have not made up our mind. Don't be worried.
We are taking notes.
Yes.
Then, my lord, kindly come to, my lord, paragraph 39. Page 13, my lord, of, my lord, the impugned order. In the
Yes.
Now, my lord, kindly see this. My lord, our old pipeline, my lord, had been damaged. So when we were applying for this Whaley permission, because it had been abandoned, my lord, from 2007 till, my lord, this, my lord, permission, there were certain areas we found had been damaged. So we sought permission to, my lord, repair those portions. Now kindly see, my lord, that those communications, how they've been interpreted by the learned judge. Para 39. In the communication by the Assistant Divisional Engineer of Southeastern Railway to ADEN, my lord, that's, my lord, and my lord, group, my lord, of engineers, my lord, of the railways, dated 4th April, an impression was given that the agency had found some damage in pipeline from Jhadia pump house to the plant of respondent number 6. The area covered by the petitioner's underpass, which needed repair, and the repairing work would be started from April 9, 2024 from 10. The said communication is a fraudulent and deliberate attempt by the railways to underplay the huge new project which was to be undertaken for reviving the water pipeline of respondent number 6, which had ceased to be used since the year 2017. Ceased to be used in 2010. Plant had been shut. Then the expressions repair and repairing work are diametrically opposite to the factual work required at the locale. In order to revive the pipeline, the underpass of the petitioner has to be crossed, which cannot but render the underpass totally unusable, rendering the valid and subsisting Whaley permissions and agreements held by the petitioner nugatory. Now, my lord, my lord, I prepared a model which I had also shown, my lord, to the previous revision bench. I've given, my lord, I've also, my lord,
You've given a model to them.
No, my lord, we gave them photographs.
You have to wrap.
Please, don't interrupt me like that. My lord, the underpass is where the vehicles are. My lord, railway tracks go over the underpass.
This is your pipe.
Correct. And my lord, pipeline is under the underpass, the old pipeline. Lordship can't see it, my lord, which is, my lord, beneath the vehicles. They have built over it.
Oh, right.
So, my lord, it comes underground all the way. It comes underground all the way. My lord, your lordship sees the two grey structures, my lord, under the ground.
Yes.
They are the underground construction, my lord, on which this, my lord, steel structure is, my lord, placed. Resting. It's not even resting on the underpass. Please. My lord, green is the surface. And my lord, that pipeline, my lord, from underground is taken over. My lord, one span is 10 meters, another span is 18 meters. There are two places. My lord, railway Railway going over it is causing no, my lord, apprehension. My lord, something which is not touching it, my lord, is, my lord, this is the finding without any evidence.
Who drafted
Nothing.
it? Who drafted it?
I didn't get to settle it as well.
Yes.
My lord, kindly see, my lord, how emphatic the conclusion is, which cannot but render the underpass totally unusable, rendering the valid and subsisting way leave permissions and agreements held by the petitioner nugatory. My lord, this is a drastic finding on fact. My lord, today the underpass is being used. Now I want to show your lordship what the condition is. The photograph, come on, show it. It's there. There's no problem. The pipeline is there. My lord, I have 2 copies. My lord. Is it the same? No, उधर के दिया था my lord.
And where is the railway track?
My lord, railway track, my lord, is on this itself. But because underpass is huge, this is, my lord, a small portion. I have not given, my lord, the length of the underpass. My lord, we are far from the railway track, but their underpass also goes through the railway, under the railway track.
I see.
My lord, your lordship looks at this, my lord. My lord, the 2 blues, my lord, are their plants.
Yes.
And my lord, one of the underpasses is there, which goes under the railway tracks.
These are.
এরকম 2টো মডেল করবে তো আমরা একটা দেখবো তুলে দিচ্ছি যখন কিছুই জানি
দিয়ে দিন গাড়িগুলো রাখতে চান তো রেখে দিন
Your lordship might have noticed, my lord, there's adhesive there to hold it together. Now, my lord, paragraph 40. Kindly see, my lord. In both the communications as well as the agreement sought to be entered into with respondent number 6, the railway authority seeks to give out an impression. Now, kindly note this. In tandem with respondent number 6, that the permission was being given for reviving an underground water pipeline. The said attempt itself evidently is to bypass the effect of subclause 12 of clause 1033 of Railway Engineer, which provides that in all cases of way-leave facilities, except railway overbridge, railway underbridge, and underground pipelines, no construction, whether permanent, quasi-permanent, or temporary, other than a kacha or pakka road, in cases the facility is expressly given for the same, is to be permitted, kindly mark the words, on railway land. If any such construction comes up subsequently, the same should be immediately removed as soon as noticed and the way-leave facility discontinued with. Now, my lord, I pause here for a moment. My lord, I should read the next para and then, my lord, next 2 paragraphs. An ROB has been defined in the code as road over bridge and RUB as road under bridge. The construction now sought to be made by the respondent number 6 is neither of the 2 and as such does not fall within the purview of exceptions to clause 12. By admission, respondent number 6 gives out that the construction now required would involve an overhead structure which would again not be an underground pipeline. Now, my lord, I've given your lordship the dimensions. 2,550 meters is, my lord, underground. My lord, a slightly charitable construction, my lord, was what was required. My lord, because of their under bridges, my lord, railway sanctions a drawing so that I also, my lord, can take water, my lord, to my plant. And my lord, for 35 meters, which is, my lord, 1.7% of the total distance, at two places, one for 10 meters, another for, my lord, 28 meters, total 38 meters, is to protect his RUB. And, my lord, third, there's no construction over the land. My lord, it's under the land so that it supports a structure which does not rest on land. Then, my lord, 42, the impugned way leave permission have been given specifically for repairing and reviving and renewal of way leave permission to operate an underground pipeline and not any overhead structure. By no stretch of imagination can an overhead structure to be built over the railway line be defined as an underground pipeline. Thus, the very effort on the part of the railway authority and the respondent number 6, now kindly see, reeks of a surreptitious and malafide effort to bypass the railway engineering code as well as the master circular operating in respect of railway lands, which comprise a policy decision taken by the railway authorities and have the status of graduate. So, my lord, the finding is that what you have done is a surreptitious and malafide, my lord, both parties together in tandem, malafide and surreptitious effort to get around clause 12 of, my lord, clause 1033, subclause 12. Now, my lord, para 44.
Sorry, just also think about it. Can they argue that no, this is not really an overground structure? It's basically an underground pipeline which is being sought to be revived. But to protect a third party's property, a very small portion has to be reconstructed over the land. So that will not violate any of the conditions of the railway code. Think about it.
My lord, para 44, my lord, now kindly see page 15. The respondent number 6 seeks to have the cake and eat it too. My lord, I'm taking, my lord, I want water too, my lord, run my plant. My lord, I've obtained permission from the municipal authorities, as I had before. I have to take it, my lord, through a pipeline, my lord, to my plant. That pipeline is in place. It's been in disuse from 2010. My way leave permission because of insolvency had expired. I have gone to the appropriate forums. Now, my lord, the impression given in the way leave permission. So, my lord, this is against the railways. And the communication is that mere repair work is to be done to the underground pipeline and a way leave permission is to be given for such purpose. Whereas the structure shown in the map submitted by the respondent number 6 clearly contemplates an overhead construction. My lord, kindly mark the words here. Over the railway property. Such attempt is barred on account of several counts. My lord, clause 12, which I said, which is on. My lord, not over. And nor does it, my lord, affect anything under. Basically, we can't have houses, huts, my lord, all that coming up on the land. Then the way leave permission sought to be given is a fresh way leave permission in the garb of a renewal, which cannot now be given in view of the intervening underpass of the petitioner, regarding which two sets of way-leaves and agreement subsist between the petitioner. The effect of the impugned grant of permission cannot be renewal as described in the permission, since the tenure of the previous way-leave permission expired long 7 years back in 2017, and there was never any application for renewal filed or pending at any point of time. Coming to the other objection taken, my lord, in our favor here. Coming to the other objection taken by the petitioner regarding violation of subclause 3.2 of clause 10.33 of the code, the same would involve a factual consideration as to whether the alleged non-feasibility of provisions of water supply applies in the present case. Although it is alleged that the Kongshaboti River nearby furnishes such alternate source of supply, evidence regarding that and as to whether use of such supply is a practical alternative cannot be undertaken by them. Now, my lord, I just pause here, my lord, for a moment. My lord, the same test should have been applied, my lord, to determine, my lord, whether any damage could have been caused or not, to affect, my lord, his RUB, which is, my lord, totally absent. Then, my lord, even apart from the same, however, in view of the above reasons, the effort in granting a fresh renewal, now, my lord, kindly see, from, my lord, a way-leave permission, it's been elevated to a lease. Renewal of an expired lease is mala fide and dehors the provisions of the master circular of the railway as well as the railway engineering code, and would be violative of the rights of the petitioner. What are the rights? What he's been given by the agreement. Can't have anything more. And I've shown the agreement, my lord, it gives no right. Now, my lord, the other argument advanced by respondent number 6 is that the petitioner is trying to frustrate the resolution plan which has been approved in connection with the CIRP initiated by respondent number 6. Clause 15.14(2)(a) of the same provides that the resolution applicant prayed that upon approval of resolution plan by the adjudicating authority, and since the resolution applicant would acquire the corporate data on an ongoing concern basis, subsisting consents, licenses, approvals, rights, entitlements, benefits, privileges shall be deemed to continue without disruption of the benefit of the corporate data. My lord, plan also, my lord, had a provision that, my lord, from on the date of closure, that is 2010, whatever was subsisting, my lord, would subsist for a particular period till, my lord, they are revived. Now, my lord, kindly see para 48. The resolution process itself commenced on January 8, 2018, whereas the way-leave permission of respondent number 6 for its prior pipeline had expired in July 2017. Hence, even from the inception of the CIRP, there was no subsisting permission or consent or license in favor of respondent number 6. The resolution plan was approved much later, and as such, the already expired way-leave permission of 6 could not come within the purview of such subsisting suits. Thus, the very premise of the argument of respondent number 6 that resolution plan is sought to be frustrated does not have any legs to stand on. My lord, I pause here. One is the clause, and the other is, my lord, that, my lord, I will not have supply of water from the same source which, my lord, the company had, my lord, all along, my lord, till 2010. That is also part of frustration. I'll come to the clauses later, my lord. They, my lord, fully protect. But, my lord, then, that apart, the clean slate theory propounded by the Supreme Court and followed by several high courts in respect of approved resolutions plans apply under IBC applies only to efface previous debts and liability of the corporate debtor to enable the successful resolution applicant to revive the concern with a clean slate. However, the said legal fiction cannot be doubly applied to generate another legal fiction of creation of new rights, which is entirely dehors the ambit of IBC itself. Well, new rights is, I've had an agreement now with the railways. I'm not coming and saying, no, I'm without permission of railways, I'm operating this underground water pipeline. Now, my lord, the rights under different laws, then the IBC cannot be deemed to be created or permitted to be created under a resolution plan, since such an interpretation of law would confer powers on the authorities prescribed under the IBC, which are not vested in them by law. Hence, even apart from the fact that there was no subsisting permission in favor of successful resolution applicant at the relevant juncture, no new rights could be created in favor of respondent number 6 merely by virtue of approval of resolution plan. With the greatest of respect, where has that happened? My lord, if I may, my lord, make the submission in question form, because I have applied, my lord, for permission, which has then been granted. Then, my lord, in embassy property so-and-so relied on by the petitioner, Supreme Court held that in the light of statutory scheme as culled out from various provisions of IBC, it is clear that wherever corporate debtor has exercised a right that falls outside the purview of IBC, especially in the realm of public law, they cannot, through resolution professional, take a bypass and go before NCLT for enforcement of such a right. Said proposition is fully applicable. Not done by us. In view of the railway authorities having themselves relied on the Master Circular on Policy for Management of Railway Land and Railway Engineering Code on several occasions, as demonstrated by the petitioner, and view of the fact that those have been adhered to at all material by railways and are binding on them. The argument that those are not binding and may be flouted by the railways at their sweet will cannot be accepted, more so at the behest of respondent number 6, where the railways themselves have not gone to the extent of arguing so. The failure of the petitioner in resolution process has no bearing on the present dispute, and as such, malefides cannot be read into the resistance of the petitioner to an illegal attempt by respondent number 6 to create rights where they do not exist any. My lord, if I'm creating a new right, my lord, then, my lord, I don't need an existing right, my lord, to be in my favor. But, my lord, I'm creating a right where no other right exists, my lord. I'm, with the greatest of respect, my lord, I'm, my lord, unable to follow, my lord, this, my lord, reasoning. The very attempt to package the unlawful grant of new Bailey permission directly to the detriment of the rights already conferred in favor of the petitioner by the railways as a renewal is itself malafide and fraudulent, being detrimental to engineering code and master circular. The other aspect of the matter is that respondent number 6 attempts to project that the overhead structure would not affect the rights of the petitioner in any manner. However, in view of the specific bar in clause so-and-so, no overhead construction can be allowed except in case of so-and-so by railway, and if discovered, the same will be. So, my lord, prejudice is not necessary. Mere fact that your pipe goes above the land and does not rest on railway land, but on another structure which is also not on railway land, my lord, is good enough. And, my lord, thus the grant of permission to construct such a structure over underpass of the petitioner is void and illegal ab initio. Also, the petitioner has raised a valid question as to whether without submission of any properly approved structural design and or safe architectural plan on the basis of sketchy sketch map relied on by the respondent number 6, Bailey permission could be granted to 6 at all. There is much substance in such contention. My lord, I can assure your lordship, the plan, my lord, was not sketchy. My lord, it was an engineering drawing. If, my lord, either, my lord, any one of the parties could not follow it, or, my lord, it was not clear to the learned judge, my lord, to say it was sketchy, my lord, is, my lord, with the greatest of respect, rather harsh comment to make. There is much substance in such contention. The railway authorities cannot take such a huge risk by approving an overhead structure which is not only violative of so-and-so, but also jeopardizes the railway line property underneath it. And the, my lord, there's no, your lordship asked a question, my lord, where is the railway line? It is not under this structure. My lord, then, and the petitioner's underpass running close beneath the surface level at the same location. Without a structural and architectural verification by appropriate authority, such construction might lead to disastrous results, causing huge loss of life and limb apart from destroying the underpass of the petitioner and the railway line property, which is public property. Such an irresponsible act on the part of the railway authorities is strongly deprecated. The action of public authorities of the stature of railways has to be transparent and above board and cannot be actuated by petty profit motives, giving a go-by to safety standards and violating existing valid agreements with third parties. Now, my lord, in view of the above, so-and-so is allowed on contest, thereby setting aside the way leave permission granted to respond number 6 for renewal, revival or otherwise by virtue of letter dated 3rd April and way leave so-and-so 4th April. All consequential steps, if taken by the respondents in terms of the provision, are also hereby quashed. The respondent shall take immediate steps to reverse any action if taken pursuant to the quashed way leave and revival permission. 6 shall at its own cost restore the property adjoining the location underneath which the petitioner's underpass runs, which has been already dug up and or which full or partial construction has been made by such site shall be immediately be restored to its original position at it stood before comment and allied works. And my lord, we came up on appeal. My lord, I just want to show, my lord, the appellate order. My lord, which is, my lord, at I can't hear you. My lord, kindly take, my lord, the can 2, my lord, once. My lord, this is an order dated 20th May. 21st May.
21st May.
Yes. Yes, yes. 21st May 2024. Of can 2, my lord.
We have it in our file.
My lord, page 23. My lord, para 2. The learned single judge has directed demolition of the pipeline, which has been put up within a time frame. This direction, if implemented, it may render the appeal partially infructuous. Therefore, the order and directions issued by the learned single judge for demolition shall remain stayed. Then, my lord, the learned single judge has also made certain observations regarding the railway administration on the ground that their actions were malafide and fraudulent. For the time being, those observations and findings stand suspended and shall abide by the outcome of the appeal. Then, it appears that the writ petition was disposed of without calling for affidavits. More particularly, the stand taken by the railway administration was not put in writing. The question would be, now my lord, kindly see the question, would be whether a permission which stood lapsed in 2017 could have been revived by the railway administration retrospectively. And if so, what would be the position of the persons who had acquired certain rights in the interregnum? Apart from that, the court should be informed as to whether there was any technical assessment done by the railway administration before revival of permission to take the pipeline above the railway underpass, which has been permitted to be constructed by the writ petitioner when the permission for the pipeline was not invoked. Let a report be filed in the form of an affidavit by the highest competent authority of the railway administration, duly supported with documents.
This report has been filed and they have taken an
This
exception.
is the exception. Now, my lord, your lordship will find, my lord, the report, my lord.
Hey,
My
report
lord, it's at page, my lord.
Oh, you've annexed the report to
Yes,
can?
yes, my lord, it's here. My lord, at page 10, my lord, your lordship will find.
Which can? Can 2.
My lord, this very, my lord.
We looked at the order from our file.
Oh, my lord, can 2.
Can 2.
My lord, the report, my lord, is, my lord, dated, my lord, 5th of July 2024.
Page 10, page 10.
Yes, my lord. And it was filed, my lord, on 19th August 2024. My lord, kindly come to paragraph 5 once. My lord, kindly see what the railways, my lord, have to say. It is stated that in genuine and unavoidable cases, the Whaley facility easement rights may be allowed by railway authorities for block of 10 years, subject to execution of proper agreements with the concerned party. It is pertinent to mention here that the user rights for any railway land, kindly see this, is not granted as a license, but only as a permission. In this case, a way-leave permission. The user rights in all cases are granted for limited purposes as are mentioned in the agreements executed with the concerned party. For further clarification, I say that the agreements executed between the railway authorities and concerned party ought not to use terms such as license or license fees, but only use terms such as permission, etc. And in cases such as the instant case, the term way-leave charges. This would naturally mean that the railway authorities retain full right to enter upon, pass through, or use the concerned land at any time without notice to any party as may be deemed necessary by railway authorities. In this connection, copy of circular, I crave leave to sign. Then, my lord, kindly have a look at para 6. Pursuant to and in terms of, I'll just read 5 paragraphs of this. Pursuant to and in terms of the aforesaid circular, on 10 July 2007, one way-leave permission for a 500 millimeter diameter municipality water pipeline from point so-and-so to point so-and-so was granted to Ramsarup Udyog Limited for a period of 10 years with effect from 2007-8 to so-and-so, vide letter dated so-and-so. Subsequently, on 27th March 2023, a letter was received by Railway Authority from the appellant seeking grant/revival of way-leave permission dated so-and-so for a further period of 10 years to meet their water requirements. In the said letter, the appellant also mentioned that due to the appellant being non-operative during the period 2010 to 22, the company went under NCLT, consequent whereto the company has been taken over by a successful resolution applicant. The appellant herein further informed that a sum of so-and-so has also been deposited for obtaining permission. Then, my lord, on 16 June, vide a letter issued to respond number 6, forwarding therewith a copy of letter of the appellant dated 27th April, along with an approved drawing, so-and-so, advised the respond number 6 to visit the concerned site jointly with the representatives of the appellant and representatives of other departments of the railways to verify if the drawings for the proposed revival are feasible. Well, this is the process of technical assessment, which is laid down in detail. In the said letter, it was also advised to check if the damage in the water pipeline can be repaired or the same would be diverted. Said inspection was advised to be held on 19 June. Then, my lord, para 9. In view of the request of the appellant, the respond number 6 herein, vide its communication dated so-and-so, being way-leave addressed to all concerned departments, intimated that a joint inspection will be conducted on 24th June 2023 at 10. The purpose of the joint inspection was mentioned to be revival by way-leave permission for municipality water pipeline of private siting of so-and-so as per approved drawing. Copy of the communication. Accordingly, on 24th June 2023, joint inspection was held and a report in respect thereof was prepared and co-signed by 6 departments, including respond number 6 of the railways. A representative of the appellant was also present and co-signed the report. A copy of the joint inspection report dated so-and-so is annexed here to and marked as annexure R6. It would inter alia be evident from the said inspection report that apart from 3 locations on the water pipeline, the entire pipeline was in good condition. Well, those are marked in the diagram as A, B, and C. Renovation of the damaged portions of the pipeline was to be done only according to the sketch map shown as Part A, Part B, and C in the drawing provided, along with the said report. It was also reported that renovation of water pipeline at damaged locations A, B, and C must be done as per the drawing enclosed. It is pertinent to mention here that the observations made in the said report were agreed to and acknowledged by all concerned Department of Railways, including the Engineering Department, Signal and Telecommunication Department, Overhead Equipment Traction Distribution Department, Electrical Department. Subsequent to the above, another communication was received from the appellant, forwarding thereby drawings, repair estimate, value of land whereupon water pipeline has been laid. A further request to restore Whaley permission was made in its letter. Then subsequently on 8th August, appellant submitted a drawing for revival of existing water pipeline. On the basis of submitted drawing, a drawing on tracing paper was concerned to the concerned department for checking its technical viability. The said drawing was checked for technical viability by Respondent number 6 on 10th August 2023 and again on 16th August 2023 by Divisional Engineer. Further, the same was re-verified by Senior Divisional Electrical Engineer and Senior Divisional so-and-so, and mainly by Senior Divisional Engineer on 22nd August 2023. Copy of. Subsequently, after the technical viability check by all concerned railway departments, the same was forwarded to various departments of railways on 11 December for final signatures. The same were co-signed by all departments on 21st and by Respondent number 5 on so-and-so, as would appear from a copy of the. Pursuant to the approval by competent authorities, an agreement for Whaley facilities was executed on 3rd April between railway authorities and appellant hearing. Along with the agreement, Whaley permission, etc. Then, my lord, para 15. It would appear from the aforesaid that despite the railway authorities having carried out all due diligence for viability and feasibility for the proposed revival of the water pipeline by the appellant, the railway authorities, by way of abundant caution, directed the appellant, vide the letter dated so-and-so, to obtain further approval of structural drawing and designs from a reputed organization. Now, my lord, subsequently, on 4th April 2024, upon receiving the Whaley permission, the appellant communicated to railway authorities that damaged portions of water pipeline needed repair. In response to the said communication, the railway authorities issued a communication on the same date to its concerns of officials, directing a supervisor to be present for so-and-so. Accordingly, the damaged portions were inspected and a report was prepared. A copy of the communication dated so-and-so, copy of letter, copy so-and-so. The said joint inspection clearly provided that repair will be undertaken, excepting the subway. There were 3 points your lordship recalls, A, B, and C, which was not near the subway. My lord, those portions should be repaired, which is across the world. Hence, all due safety measures were taken. In connection with direction of the railway authorities communicated to the appellant on 3rd April, the appellant submitted a structural drawing and design prepared and vetted by a reputed organization, namely Breslau Infrastructure and Technology, on 17th. However, due to certain minor font modifications in design, the appellant resubmitted the same on 18th. Then subsequently, on 28th April, the appellant submitted structural drawings and design calculations certified by Chartered Engineer Rakesh Srivastava. Copy of the letter. It is only after investigation on account of safety, viability, feasibility on the basis of structural drawings and design submitted by the appellant and further structural drawings and design certified by Chartered Engineer and submitted by appellant on 23rd, the final permission was granted by letter dated so-and-so. Earlier, the Respondent number 1, Orissa Metallic, applied for so-and-so. After due diligence, the concerned Department of Railways and agreement for Whaley for construction of so-and-so was given. And, my lord, clause 12 and 29, which I had placed before your lordship, my lord, of their agreement, my lord, are also, my lord, set out. And, my lord, which says, the water pipeline, and kindly see 23, the water pipeline measuring so-and-so already existed to so-and-so and thereafter from the year to till date. To state that the water pipeline has not been removed by any party after expiry of 10 years or thereafter. Hence, Whaley charges against such user are payable by the concerned party. Then, my lord, in view of the scheme of amalgamation, all assets stood merged. My lord, that's different. And then, my lord, para 25. In view of the above, and under Railway Board circular dated so-and-so, which seeks to ensure railways' financial interests are not hampered, Whaley permission for so-and-so, copy of circular. In the meantime, Chapter 1033 of Indian Railway relied on by respondent number 1 was corrected. Advance correction slip dated so and so. Under chapter clause 14b was amended to waive permission in respect of open drainage and surface stroke overhead pipelines should be allowed only in unavoidable cases. So it's not a complete bar, even if it's overhead. Well, they're relying on that. In any case, fresh permission for this in favor of third parties should not be given. All efforts may be made to have existing open drainage and surface overhead lines replaced by underground. Copy from a bare perusal of 14b of railway, it is evident that waive permission for surface overhead shall only be granted in unavoidable in the instant case, since the water pipeline was already in existence and was damaged due to construction. Well, kindly see of the RUB by respondent number 1, the grant of permission for laying a minuscule portion of water pipeline portion, which was cut through by the construction of RUB overhead, the surface was an exceptional, unavoidable circumstance and therefore covered under 14b. My lord, I have said more. My lord, railways say even under 14b. That, my lord, there is no bar. And my lord, furthermore, master circular on policy has been issued so and so. Renewal, my lord, I will place this clause, but my lord, on expiry of lease, my lord, this was quoted in the judgment, which says renewal has to be after expiry. Further renewal up to 30 years of a so-and-so can be done based on mutual agreement between railway. Market value, copy of it. I say that master circular in no manner restricts the railway authority to renew a permission after the expiry of the same. It is usual practice. Now kindly note, this is what the railways are saying. It is usual practice that permissions granted to private parties are renewed at a date later than that of the expiry date. In the instant case, since permission granted expired in same was renewed from such date till so and so. It is stated that out of the 2,250 meters water pipeline, only more or less 38 meters has been hindered by the construction of RUB. In view of the above, and having no alternative, permission for laying so and so was granted. Said permission was granted pursuant to clause so and so and clauses 12 and 29 of the waive permission dated executed, which is also annexed. It is pertinent to emphasize that permission granted to the appellant was done after taking into consideration all safety measures and viability of the said permission. As more fully mentioned, it is only after joint inspection carried out on so and so by all concerned and technical viability check of drawings submitted by appellant by all concerned senior technical officials of the railways was the permission granted to the appellant. It is further mentioned that only after completion of all technical examination of the drawing prepared by appellant and submitted on so and so, the same was approved, etc., etc. Then, my lord, it is in the offers that I respectfully state and submit that waive permissions for water pipeline, railway bridge granted have been lawfully given by railway administration as permission for water pipeline and for road under bridge are separate. It is reiterated. So, my lord, they are justifying RUB, my lord, over my pipeline because it's a separate permission. It is reiterated that waive permission is not a license but only permission granted for a limited use and it retains full rights, etc. My lord, this is, my lord, their, my lord, report. And to this, my lord, an exception has been taken. My lord, I can place. My lord, I can continue, my lord, or my lord.
Or?
No, my learned friend said, my lord, in case, my lord, I have become too monotonous.
No. If it's hurting your throat.
No, my lord. Now, my lord.
10, 12 minutes more.
Yes. My lord, kindly now have a look at, my lord, their exception. Which is, my lord, paragraph 8. My lord, can 2, my lord.
Yes.
Paragraph 8, in the report, it has been alleged that the renewal was from 2017 to so and so. The same is false and falsified and are contradicted by documents on record, including the agreement dated 3rd April 24, which had been disclosed at the time of hearing of the writ petition by which has now been disclosed along. It is evident therefrom that there has been no renewal as claimed. Both the appellant and railway have suppressed this from the Honorable Court to mislead this Honorable Court. It is clear from the aforesaid agreement that there is no renewal of permission, but the grant of fresh permission with effect from 3rd April 2024. The railway respondents has conferred benefit upon the appellant in the guise of a purported renewal that the railway sought to confer for wholly unexplained reasons. In this connection, states that railways have refused similar permission to several industries and educational institutes to carry water along railway tracks, as a consequence of which they have been compelled to draw water from Kongshaboti. Applicant have been able to ascertain various parties, including so-and-so, are some of the entities who have been compelled to set up. Then, para 9, the court's requirement was, please tell us whether a technical assessment, had been done. Para 9, it is submitted that no proper inquiry or study has been carried out to ascertain the effect of construction of writ petitioner. Significant that drawing of significant particular and calculation have not been approved by railway authorities. In such circumstances, applicants deny and dispute. The railways have said inspection, assessment of drawings by their own engineers, assessment of drawings by third-party engineers, assessment of drawings by a chartered engineer. Has been done. Before the ultimate permission is granted. Then this is really on no basis. Then 10, that at the time of finalization of structural drawing, the chief bridge engineer of Garden Reach was consulted and he approved the design by putting his signature on so-and-so for RUB1, RUB2. However, while purportedly finalizing the drawings of overhead, which was run over the chief bridge engineer who had approved RUB was not. So, who the expert would be, they decide. How will the assessment take place? Which with the greatest of respect, there's no right, to that effect, conferred. Here, there is internal assessment as well as external. That it had to be the same external, examiner or external engineer, which was employed for RUB, there's no such requirement. Then, the documents are incomplete, unsigned, and are not signed by persons who would have been required to sign the same in normal course. The same are otherwise contradictory, unreliable, and have been brought in existence as an afterthought. The report is full of contradiction and does not answer the question. Then, after execution of agreement dated 3rd, approval of drawings is carried out. It is alleged that structural drawing and design was certified by structural engineer and chartered engineer. However, the plans allegedly submitted by structural engineer and experts of appellant as referred to in so-and-so were not approved by the railway engineers. There is no endorsement of the alleged approval of design in accordance with validity. With the greatest of respect, the railways have already approved. They wanted certification from outside agencies. And that certification also needed to be approved, as long as it matched the view of the railways, is all that is under consideration. Now, it is therefore evident that the railways have acted in an arbitrary, incorrect manner, acting in connivance, that in the report do not address the referral issues contained, but legal arguments are being sought to be made. Statements contained in so-and-so are misleading, incorrect. This is all. The drawings are there.
The water pipe has been repaired now.
Entirely repaired. Yes, it's been done.
It's ready for use, but
Yes.
it can't be used now.
Can't be used.
Yeah, and it has been the new structure. It was built about a year ago. About a year ago. In the last 1 year, has it had any adverse effect?
Not possibly.
your-
There is no water connection has been given till it's
That is
the
why.
structure.
That is why.
It is-
All right.
Now, kindly have a look at the railways reply to this exception.
Reply টা কোথায় পাবো? They have annexed it. No.
It's a separate document, my lord. Reply of the railways.
এই তোমরা অ্যাপেলের সাইডে সব দড়ি দিয়ে বেঁধে ফেলো কেন বলো তো? করো না তাহলে, খাতা খোলো, দেখো ফাঁকা আছে, অরিজিনাল সাইডে জিজ্ঞেস করো। খালি আছে। টিউজডে 3:30 PM লিখে দাও, মার্ক 3:30 PM.
Could it be 3 p.m., my lord? 3:30, my lord, may always.
Why? Because Tuesday, quite safe. Sure.